Robin Yeamans, and I've been an attorney since I got out of Stanford Law School in 1969. And my goal was not particularly to become a divorce lawyer, but there was a lot of pull for a woman to go into family law, and eventually, after a number of years of doing other things, that was where I ended up. And I had experience in community organizing, and I was sitting in the courtroom in San Jose, California in 1996, and suddenly I saw a judge who would give custody almost automatically to abusers, and most of whom were men, but there were female abusers as well, and they were the ones who got custody. And we were like, I gathered some of the victims around, and we were trying to figure out what's happening. Is it this judge? Is it this county? Is it this state? And what we discovered had happened was that in the reform of welfare as we know it, they had determined you could get a certain number of women off of welfare if you raised child support. The federal government commanded all of the states to raise welfare, to raise their child support awards, and to put in an effective enforcement mechanism. And so in California and the other states in 1992, child support jumped up and became very mandatory and enforceable. And that was what kicked off what we call the custody wars. I had been doing divorce for 2 decades at that point, but it was at that point that the divorce wars broke like a wave on family court. And the judges suddenly were like, what do we do with all these cases? And that was when they brought in mediators. That's when we tried special masters, farm them out to psychologists. What can we do to get rid of these cases? And family court services, mental health experts. So that's when all the alternative special masters, private judges, that's when all the alternative solutions suddenly came in. That's when Dr. Richard Gardner publishes his book on parental alienation syndrome, so-called rotten pseudoscience. And the abusive fathers were encouraged at that point to seize custody, and some of the mothers who were in that same situation, and the wars began. Then by 1996, some of the people who had lost custody were reeling and going, what has happened to us? We're declared to be mental dangers to children who we've raised, who are said to be perfectly wonderful, healthy children, and yet we are now found to be mental dangers and declared that we have to be put on supervised visitation, for which we must pay, and if we run out of money, we can't see our children any longer. So in San Jose, California, the mothers and fathers together began picketing the courthouse and demanding changes. The media absolutely blacked us out. But the parents picketed in determined manner for an entire year, and finally the court began listening. We had a superb presiding judge, Judge Komar, who listened, had a committee talking to different experts and things, but they didn't listen to any parents until at one point the parents had been picketing the office of a private psychologist, and to get the parents to cut that out, they agreed to let them speak to the committee. And during this entire year, the parents had also engaged in extremely informative but very factual and militant at the same time leaflets, which can be seen at www.ncfjwest.org, in case someone says, what's a leaflet? How do you write them? What do they look like? And they were so interesting and informative, the lawyers took them up, and they had legal points in them that when the parents were like ants scrambling around looking for anything, they would find that crumb of law that the lawyers had overlooked and put it into the leaflet and inform the lawyers. And when you armed the lawyers, they would inform the judges, and it did have the effect of transforming the entire atmosphere in the courthouse, which polarized into a battlefield. I would walk into the courthouse and people would turn their backs on me, and the whole thing had polarized. But in the end, the parents, men and women united, not fighting each other, but attempting to change a system, prevailed. Judge Komar issued his protocol, virtually eliminating the special master, which is the same thing as parent coordinator system, calling for a great limitation on the use of attorneys for children, which would be law guardians, limiting the use of farming cases out to psychologists, and saying that attempting to smash the cronyism system by saying that such appointments should be given out on a fair and rotating basis. And the Komar protocol can be seen on that same website. And at this point, suddenly everyone was friendly to me, thinking that and I certainly responded with friendliness. Of course, in the back of my mind, I'm thinking, do you think I don't remember when you turned your back on me? But hey, if they wanted to be friendly, now the parents got, and with the new setup, the parents were able to get their children back, and it was as if there had been a mass kidnapping, which was now reversed. And except for maybe 5 or 10% of the parents, they all got their children back eventually. It might take years, it might take 8 years. Everyone got their children back. The organization quit meeting because everyone took their little birdies back into their little nests. So I've had to begin building it up from the ground again because everyone was so content. And this is the method which works. And every place in America where the father's rights and the mothers have settled down and started lobbing shells at each other, they have all gotten nowhere. Well, in the course of doing all this, the National Coalition for Family Justice is both in New York, in California. It's a national organization that Monica Getz in particular began back in the mid-'80s. So it has been around a long time, helping people with their cases and, providing specific help that will assist people getting through their cases to the extent possible. Monica in New York has been able to strong-arm lawyers into helping people. In general, in California, we've focused on getting materials out that will help people do their cases without lawyers, because we know that when you can have modification after modification after modification of a custody case, even if you can afford a lawyer at the beginning, virtually no one can afford a lawyer to go through the whole process. In California, we have an interesting process which is called Notice of Limited Scope Representation, so that an attorney can come in for a small part of the case. So you may not come in for the financial case, but just come in for one motion, just come in for the custody aspect of the case. And that has been a great help and has made it a lot easier to get attorneys to be willing to come into a case when they know they can get out of the case without having to impoverish themselves as well as the litigant in doing the case. And we would certainly like to see the ability to what they call unbundle, or do just a part of a case, be adopted in other states. It has worked so well in California. I have been in courtroom where the judges have the forms to sign on as a limited scope attorney right there in the courtroom. I will say in California there are 3 attorneys who are certified as specialists in both family and appellate law, and I'm one of those 3 attorneys. And we try to help not just litigants without attorneys, but also attorneys remember how to prepare a case for appeal. Because if you don't get your objection on the record, if you don't say what you would have presented if the judge would have allowed you to do, if you don't get everything on the record, you are not going to have an appeal. And if you have a judge who won't let you say things in the courtroom, you have to write it up in a declaration and file it with the clerk's office so that there will be some record. The basic principle of having an appeal is that the trial judge has to have been offered the opportunity to correct their mistake. If somebody just sat there and the judge never heard what you wanted to do, or if your piece of evidence was never even marked, then there's nothing for the Court of Appeal to do.